The second reason we use trust is for disability planning. As I mentioned earlier in the introduction, about half of all people unfortunately eventually become disabled today. Now, if you have a will, does it help you if you become disabled? Well, no, because a will takes effect at death. It's not a plan for disability. So what I see out in the public when I give my public seminars, most people have wills and they're unaware that they don't have all the issues addressed. They have no plan for disability. The living trust solves this problem because unlike a will, a trust takes effect while you're living, which is why it's called a living trust. And what happens with a trust is you say, my estate starts today, not when I die. And for now, I'm putting myself in charge. So we call you the trustee of your trust estate. Now, if you start your estate today, you can write in your own plan for disability. You say, I'm in charge now, but if I become disabled, I name so-and-so to step in. Now, the law in New York says when you set up a trust where you name a backup trustee, this defeats a guardianship. So that judge cannot appoint somebody for you if you said who you wanted, only if you didn't say who you wanted. So you know in the event of disability, you get the person or persons you choose. Now, make no mistake about this. Getting the person you choose in the event of disability often makes the difference between keeping your home and life savings and losing it. Because the person you choose is going to do what? They're going to call the other law firm, in this case, myself or one of the attorneys here at Ettinger Law Firm. They're going to say, Mike, you set up my husband or wife or mom or dad's plan 12, 15 or more years ago. Now so-and-so needs to go into nursing facility. What do we do now? This is a call we get many times a week. What do we do now? Well, I can't tell you what we're going to do in your case, but I can tell you that if we have that enhanced prescription strength power of attorney and we have the trust set up, we can act immediately and do whatever the law allows. And remember, the system is move it or lose it. So the sooner you act, the more you get to keep. So what I'm getting at is that it's essential to have a plan for disability as well as a plan for death. Now, let's discuss briefly how this revocable living trust works. Let's say your name is Mary Jones. You set up something called the Mary Jones Living Trust. You appoint yourself Mary as the trustee. Now, for the trust to work, you have to put your assets into it. So we're going to retitle your assets. The law firm will prepare a new deed, and I'll deed your home from you, Mary, to you, Mary, trustee of the Mary Trust. And I'll show you how to change the name on your investments and your bank accounts. And now everything will say Mary, trustee of the Mary Trust. Now, the trust is a separate legal entity, but you, Mary, own it and control it. So you can buy and sell the same as before. You file the same income tax return as before. Everything's exactly the same as before, except like a few million other people around the country, your assets are titled Mary, trustee of the Mary Trust. The difference really only occurs on death or disability. What happens when Mary dies if she has a trust? Well, there's no probate because technically Mary doesn't own anything. It's all owned by the trust. And here's the key. Because the trust is a separate legal entity, it doesn't die when Mary dies. It's still there. So what happens then? The backup trustee steps in. One or more of the children. What do? Just like the will, they follow Mary's instructions. After I'm gone, divide the assets equally among the heirs. So it settles more quickly and less expensively than a will because there's no probate court proceeding. And what happens to your old will? With a trust, we cancel it or revoke it. You get an ancillary document with a trust. It's called a pour-over will, P-O-U-R, pour-over will. Cancels your old will as a matter of law because the later will cancels the earlier one. And it says if for any reason I left something out of my trust, pour it in there after I'm gone because my wishes are written in the trust. So you need that just in case. Now, what happens on disability? Well, we don't have a guardianship proceeding because we name the people we want to take over if we become disabled. So the people we choose take over, usually one or more of the adult children, follow our instructions, which are take care of me, keep my affairs in order, maintain my investments, pay my bills, because I plan to beat this thing, which is so important today because many people recover from strokes, heart attacks, serious operations. And when I recover, what do I want? Well, like everyone, I want to step back into my old shoes, take back the reins, and it's a private matter between me and my family. I'm not going to court and asking the judge for permission as I would in a guardianship proceeding. Unfortunately, not everybody recovers from disability. Some people need long-term care, unfortunately have to go into a nursing facility. Then the trust says get in their backup trustee, talk to the elder law firm, move to transfer and protect, whatever the law allows. As I mentioned earlier, we can always save at least half, provided the family's in control and they have the power to move the assets, often hundreds of thousands. We use the trust also to avoid what we call the multiple probate problem. Most people are unaware that if you own property in another state and you have a will, you have to probate the will not only in New York, but also in the other state where you own property. So you need 2 lawyers, you have 2 court proceedings, you pay 2 fees. That's called a multiple probate problem. You have property in 3 states, it's three probates. When you set up a trust, the law firm can deed property from any state into the trust. You avoid all the probates. And finally, we use the revocable living trust estate plan, the first pillar, to avoid the New York State estate taxes. Now, the first $1 million of assets in New York is exempt from tax. But what is your estate for tax purposes? Well, your home, your investments, your bank accounts, all your real estate, your IRAs, and any life insurance that you own is part of your estate for state tax purposes. Now, add it all up, if you're under $1 million, it's simply not an issue. You don't have a taxable estate. But if you're over $1 million, the tax rate in New York starts at 41% of the amount over, and it goes down to about 10%. So, for example, if you have an estate of about $1.1 million, remember the first $1 million is free, you owe almost $40,000 in taxes on the $100,000 you're over. At $2 million, the rate is just about 10%. You owe just about $100,000 in taxes. The first $1 million is free, 10% of the second $1 million, $100,000 in tax. You can legally avoid the tax if you have a spouse and you create 2 estates, one for the husband, one for the wife, generally by setting up 2 trusts, one for the husband, one for the wife. You split the assets, and for example, you deed the house half to the wife's trust, half to the husband, split up the monies. If you set up the 2 trusts and the 2 estates, you can pass $2 million tax-free instead of $1 million. How much do you save in tax? Depends how much you were over the $1 million. Somewhere between $40,000 and $100,000 in tax is what you would save. That plan must be set up, however, before the first spouse dies. So let's review the basic plan using a revocable living trust. First, avoids guardianship proceedings on disability. Crucial to have a plan for disability because eventually half of us do become disabled. Avoids probate court proceedings at death. Clearly desirable to avoid court proceedings at any time, but especially for our loved ones. Avoids a multiple probate for out-of-state property, and reduces or eliminates the estate tax for couples in New York who have estates over $1 million. That is the first pillar of estate planning.